Great, thank you very much. And signal if I'm going too fast at any point, okay? Our LGBTQI2S communities are appreciative of the interest shown us by the federal government in a whole range of ways, reaching right up to the Prime Minister. In my time this afternoon, I intend to make 4 points. The first, articulate our general perspective or approach. Second, express Egal Canada's agreement with the submission by Gentile, Hooper, Kinsman and Maynard, whom you'll be hearing from, it turns out, after me. I want to call for legislative change in 2 respects. The first is the failure in Bill C-75 to address the problem of surgeries on intersex children. And the second is a problem in the otherwise welcome efforts to undo past discrimination against our communities. So let me start just briefly with the overall perspective. We come at these issues at Egal Canada from a general approach attuned to LGBTQI2S equality, dignity, and inclusion. Fundamentally, we're keenly conscious of the long history of the criminal law's sexual and moral offenses being applied against our communities discriminatorily, discretionarily, and disproportionately. We would emphasize intersectionality, conscious that members of our community experience overlapping disadvantage in virtue, for example, of being queer people with disabilities or being racialized or Indigenous trans people. And I would emphasize the symbolic significance of the criminal law on matters touching our communities. So the Victorian prohibitions relating to sodomy, body houses, indecency, you name it, have consequences beyond their enforcement and convictions obtained. The mere threat of their enforcement can operate powerfully, and it operates more powerfully against those most vulnerable people who might not get good legal advice or have any idea how to respond. Second, very briefly, I just wanted to signal that we fully endorse the report from Kinsman and al. That you're about to hear from. We support their calls for Bill C-75 to go further than it does in a number of ways, and we affirm their call for adopting clear, evidence-based guidelines on the use of criminal law in prosecuting cases of HIV non-disclosure. Let me turn now to non-disclosure. Let me turn now to the 2 legislative changes that it's possible nobody else will raise with you. The first concerns intersex children. Subsection 268(1) of the Criminal Code sets out the crime of aggravated assault, and its subsection 3 addresses excision. It specifies that wounds or maims include cutting a person's labia majora, labia minora, or clitoris. But then it provides an exception where surgery is performed for the purpose of the person having normal reproductive functions or normal sexual appearance or function. And the alternative basis for the exemption from aggravated assault's application is when a person is at least 18 years of age. In other words, paragraph 268(3)(a) deflects the protections of the criminal law from children on whom surgery is inflicted for the purpose of giving them a normal sexual appearance or function. And the idea of the normal sexual appearance or function is a vehicle for cis-normative assumptions about which bodies are medically correct or normal. I can't undertake a full charter analysis this afternoon, but section 268(3) raises concerns about security of the person and equality. Moreover, international human rights bodies have recognized that so-called corrective surgery of children whose genitals are characterized as abnormal violates their personal autonomy and integrity. So we urge you to amend Bill C-75 to modify 268(3). And the final point concerns to the legislation
Thank you for giving me the opportunity to address your committee. I am a clinical and research psychologist. Since 1976, I have seen over 1,600 children and adolescents who experience gender dysphoria. I was the chair of the Sexual and Gender Identity Disorders Work Group, who was part of the task force for the 5th edition of the Diagnostic and Statistical Manual of Mental Disorders published by the American Psychiatric Association. I have published over 300 peer-reviewed articles and book chapters on this topic, so I feel that I have the necessary background to address elements of Bill C-6. Up front, let me state that I am in full agreement that mental health clinicians should not attempt to change the sexual orientation of individuals under the age of 18 years. However, I want to point out quite strongly that contemporary mental health clinicians do not engage in such practice and have not done so for decades. Mental health clinicians do not practice conversion therapy with gay, lesbian, or bisexual adolescents. Where I disagree quite strongly with Bill C-6 is its additional focus on gender identity in children and adolescents. Since the state of California passed similar legislation in 2012, there has been an insidious conflation of sexual orientation and gender identity. Not only does the proposed legislation erroneously conflate two very distinct psychological phenomena, it also completely ignores developmental considerations. The original criticisms of sexual orientation change efforts were targeted at the unsuccessful efforts by clinicians who tried to change the sexual orientation of adults. Bill C-6, by conflating sexual orientation, now targets clinicians who work with children as young as the age of 3 years and their parents. In my view, this is a serious mistake. Do politicians appreciate this conflation? The background scientific material provided to this committee by Phillips and Walker is completely silent with regard to what is known about best practice therapy for children and adolescents with gender dysphoria. No well-trained mental health clinician attempts to coercively change the gender identity of either a child or an adolescent. Well-trained clinicians consider what the best therapeutic approach might be to reduce gender dysphoria, a mental health diagnosis in the DSM-5, and the distress associated with it. And there are various ways in which this can be accomplished. The problem with Bill C-6 is as follows. At point 5 at section 320.101, it defines conversion therapy in part as a practice, treatment, or service designed to change a person's gender identity to cisgender. Yet, in the same paragraph, it states that this does not include a practice, treatment, or service that relates to a person's exploration of their identity or to its development. Bill C-6, like many initiatives that have preceded it, is completely vacuous in defining what such exploration would look like or constitute. Let me give you a couple of examples. A 3-year-old boy expresses a very strong desire to be a girl. When asked why he wants to be a girl, he tells his parents that he likes very much to play with Barbie dolls and to wear dresses. Under Bill C-6, can a mental health clinician explore with such a child this belief? For example, would it be acceptable to point out that boys can play with Barbie dolls too? A 7-year-old boy expresses a very strong desire to be a girl. When asked why, he says that all the boys in his classroom at school are mean and rough. In contrast, all the girls in his classroom are kind and gentle. He does not want to be mean or to play rough. Under Bill C-6, can a mental health clinician explore with such a child these beliefs? For example, would it be acceptable to point out that not all boys are mean and rough and that not all girls are kind and gentle? A 14-year-old girl expresses a very strong desire to be a boy. The girl also has a diagnosis of autism spectrum disorder, which includes the propensity to think in very binary terms. Because she does not feel like other girls, she thinks that the only option is to be a boy. Under Bill C-6, can a mental health clinician explore with this adolescent the idea that there are many ways that one can be a girl? In my view, Bill C-6 should be modified in one of two ways. Delete entirely any reference to gender identity and restrict it to sexual orientation, the original target of criticism of conversion therapy. Failing that, Bill C-6 should be extensively revised in terms of explaining the scope of what exactly it means to engage in exploration of gender identity or to its development. In other words, provide objective markers. Such a revision would help both clinicians and family who have a child or adolescent experiencing gender dysphoria understand what the legislation truly intends to target. Thank you.
Thank you. Thank you very much. We'll now go.
Points raised by Egal and Mr. Leckie. Before I begin, I would like to acknowledge that these proceedings are taking place on unceded Algonquin territory. As indicated by my colleagues today and last week, Bill C-75 is a wonderful opportunity for us to honor the apology made by the Prime Minister and address the continued criminalization of the LGBTQ2SIA community and the lack of bodily autonomy experienced by members of our community. That said, before I make my critiques and recommendations, I would like to offer my commendation for the inclusion of the repeal of anal intercourse as a crime. This repeal is a step forward and the change is long overdue. Thank you. However, if we stop at this issue, this bill will become a lost opportunity for so many other overdue changes that would bring justice and equality to the LGBTQ2SIA community and all Canadians. We are everyone, and we are everywhere. The lack of repeal of the Body House law, vagrancy, nudity, immoral theatrical performance, and indecent exhibition laws remains a serious point of contention between our community and the government. The apology delivered last year by the Prime Minister explicitly refers to the use of the Body House law to criminalize LGBTQ2SIA community. However, no action has been taken on this issue. The effects of these laws continue to cause harm in our communities. The people who have been charged and convicted under them have lost their families, their loved ones, their careers. They live in precarious situations. Some have taken their lives. Those who are still with us cannot have their records erased until this law is repealed. They continue to live with the shame of such treatment. Some have for over 30 years. This state-caused harm has been acknowledged by the Prime Minister himself, and yet continues to be put aside. The criminalization of sex work has been ruled unconstitutional by the Supreme Court, specifically the 2013 Bedford case. Unfortunately, the PCEPA reconstituted a number of those crimes deemed unconstitutional, including communicating, obtaining sexual services for consideration, material benefit from sexual services and procuring, and advertising and material benefit and advertising, which work together to isolate sex workers. They cannot screen clients, hire security, or administrative support. Such laws continue to put sex workers in danger. Local, provincial, and federal police services continue to use this existing legislation to harass and criminalize folks who should be allowed to do their job with the support and protection of the state. We strongly recommend that a clear decriminalization of sex work be included in C-75. Bill C-75 fails to protect intersex children from non-consensual surgery. In June 2017, the CCGSD came out with our pink agenda, making it clear that we stand in solidarity with intersex communities and their right to decide what is best for their bodies. And yet today, Section 268(3) of the Criminal Code of Canada allows non-consensual surgery by medical professionals to alter the bodies of infants and children whom they perceive to be ambiguous, that is, intersex. In doing so, the bodily autonomy of those infants is removed by the state, the parents, and the medical practitioners who make these decisions and perform these surgeries. Bill C-75 fails to limit the laws that allow the criminalization of HIV. We have been asking for clarity on this. To this day, and regardless of the government's own report, criminal justice system's response to the non-disclosure of HIV, which states that HIV transmission is a public health issue instead of a criminal issue. The non-disclosure of HIV is treated as an aggravated assault, sexual assault, in the criminal justice system. In that same report, it is demonstrated that, and I quote, sexual activity with a person living with HIV who is taking treatment as prescribed and has maintained a suppressed viral load poses a negligible risk of transmission. The continued ability to criminalize the non-disclosure of HIV is in direct opposition to the government's own evidence-based report. Bill C-75 can be used to limit this law. It can be used to ensure that non-disclosure of HIV is not criminalized and that members of the LGBTQ2SIA community are not discriminated against by homophobic, transphobic, or otherwise rogue Crown attorneys. However, as it is written, it does not. Finally, my last point is that Bill C-75 fails to properly define marginalized person. While C-75 would require judges to consider the circumstances of an accused person from a marginalized group when deciding on bail conditions, the lack of definition of marginalized persons can be interpreted to exclude the LGBTQ2SIA community. We strongly recommend the explicit inclusion of LGBTQ2SIA in the definition of marginalized people in C-75. Thank you very much for listening.
Thank you very much for your testimony, and I appreciate it because a lot of the issues raised by this panel are new and ones that were not